All right, this is where we left off. This is part two of chapter 5 on surveillance and modern technology. And we were talking about undercover officers and their ability to use a wire. Because of that general concept that the Fourth Amendment does not protect against third party communications, it is not a Fourth Amendment violation for officers to use a wire or have an informant use a wire when communicating with suspects or individuals. Um, all right, so the bottom line, police interception or recordings of communications must comply with Fourth Amendment and state and federal statutes. However, in general, police may lawfully record any statements. Okay, so we have tape recorders, thermal devices, hearing devices, x-ray machines, tracking devices, GPS, and dogs. So intrusive devices, electronic, mechanical, or other device. If the general rule is, if the device allows law enforcement to obtain information that they generally could not obtain through natural devices, meaning their eyes, their ears, that would be, then the device would be considered a intrusive device. Okay. If the device is used to gain access to communications that an officer is not otherwise able to hear. That's what I just talked about. All right. Honest Crimes Control and Safe Streets Act of 1968 is significant, and you should know this act because it's the first time that the federal government has legislated what officers can and cannot do when using electronic surveillance. So, what they basically were talking about in 1968 was interception orders. An interception order is, in plain language, it is a wiretap. So, an interception order has many of the requirements of a search warrant. However, it is a separate type of order, but it is an order that requires a court's signature or a neutral third party signature, just like a search warrant. An interception order requires probable cause. So in many ways, it's like a search warrant, and then in many ways, it's very unique and different from a search warrant. So we're going to go into details. So number one, an interception order requires a judge's signature. Court must make certain findings before an order can be issued, and the order will limit who may review the received or intercepted information. So it is like a search warrant, and that requires a magistrate's signature. Here's where it's different. A search warrant is generated generally by law enforcement. So law enforcement generates a search warrant, presents it to a judge, and a judge signs the search warrant. The DA's office really doesn't get involved with the actual generating and the signing of the search warrant. The DA's office generally, depending on the policy of each individual office, but generally, for instance, in Fresno, the DA's office is not going to be involved with that search warrant until it's already been executed. So in most cases, the first time a prosecutor is going to see a search warrant is when the arrest reports come in, and attached to those arrest reports is going to be the reports of the search warrant, the execution of the search warrant, and a copy of the search warrant. But with an interception order or a wiretap, the DA has to sign off on the interception order prior to the magistrate's review. The other individual that has to sign off is the primary or chief officer, law enforcement officer for the law enforcement agency who is seeking the interception order. So, for instance, I was involved with a task force, a general task force that was doing wiretaps on drug sales. And that law enforcement agency was a mix of both local law enforcement and federal officers. So there was a federal officer or a commander that was responsible for the law enforcement unit. That commander was required to sign off on the interception order. It's going to be the officers who actually generate the interception order. So they're going to write a draft of that order. They're going to submit it to the DA's office, where the DA's office is going to have a procedure. Each agency is going to have a different procedure. In Fresno County, it went to the assistant DA, the DA underneath the county DA, first assistant. And then that assistant assigned it to the chief for the unit that did legal research for the DA's office. So it was the attorney that did the legal research. It was the chief assigned to supervise the legal research team, and the assistant DA. All three received a copy of the interception order, the draft. Each of them reviewed it independently, and then as a group, the three got together, reviewed their assessment of the order, noting any changes that they felt needed to be required, and then submitted it back to the law enforcement agency. And then once those changes were made, a final draft was submitted to the DA, who by law is required to sign it. So here, the law also requires that if the DA is not available, then the DA's office has to sign a declaration saying that the DA is not available and that the assistant DA will sign the interception order. And that is submitted to the court. So the court, it's a huge distinction between a search warrant. A search warrant, law enforcement creates, submits to the court. The interception order, the DA has to sign it, not an assistant DA or a deputy DA. The district attorney has to sign that interception order. And if they're not available, so if they're away on a conference, if they're out because of some kind of medical reason, then a affidavit declaring that the DA is not available, physically available, and then the assistant DA can sign it. And so what the court receives is an interception order signed by the DA, signed by the chief investigating officer that's in charge of the investigation, and only then will the court then review and certify the interception order. The next distinction between an interception and a search warrant is that in that interception order, they have to certify in the interception order that those individuals who will be listening to the interception order, they have to be certified by in this case it was the federal government. So only those who have been tested and are certified to listen into a wiretap are allowed into the next issue, which is you have to certify in your interception order that you have a secured location. That location has to be secured. It has to meet certain standards. Once that interception order is signed, only those individuals who are qualified to go into that room are allowed to go in the room. So what's in that room? With modern technology, you're going to have a bunch of computers because a computer can record and document and do a lot of different things. So you're going to be, it's kind of just a stale room, chairs, desks, tables, and computers. But once that order is signed and that room becomes sealed, and only those individuals that are certified and that are allowed to go in that room can go in that room. no one else. So if I'm, for instance, if I'm the district attorney that's involved in this investigation, then I'm going to be the one that's going to prosecute whoever is identified in this wiretap. I would not be allowed to go in that room because I'm not certified to be in that room. I would only be, I would only get the information after the interception order is completed, the investigation is completed, and police reports are submitted to the DA's office. So that's a huge distinction between that and a search warrant. In a search warrant, once that warrant's signed, you can have an army of individuals go into and execute that search warrant. And you don't have to declare to the court who's going to be involved with the search warrant. So if I was going to go, for instance, into a large office, I could have, several law enforcement officers. I can have individuals that may have special knowledge about this particular business that I'm executing the warrant on, and the court would not have to certify or approve or be aware of who's actually going in the building. With an interception order, the court makes an order that says, you're limited to the number of people that are allowed to go in that room, and nobody else is allowed to go in that room. So it gets even more restrictive. You must submit every 10 days. You, law enforcement, have to submit a written report to the judge who has certified or signed the interception order. And that report says who you've been listening to, or at least the phone numbers that you've been listening to, the information that you've been receiving relevant to your interception order. And it also will identify if there's any confidential or privileged communications that have been received as part of the interception order. And then the order is only good for 30 days. At the end of 30 days, the court can terminate that interception order. After the first 10 days, if the court feels it appropriate, they can end your interception order. So very restrictive. There's constant communication between the law enforcement agency doing the interception order and the and the court. So there's constant communication. There's an actual written report that goes to the court after 10 days. Privileged communications, if those listening in on the phone calls determine that this is a privileged communication, they stop the recording. They will splice out the privilege, what they believe to be the privileged communication, and they will store it in a separate recording file. And then at some point, the court will review those privileged communications and determine what to do with them, if anything. But they have to be identified, separated from, and recorded separately. And then generally those privileged communications are going to be ordered sealed by the court, and no one else is going to have access to those. And there's a log sheet. So every time a law enforcement officer is listening in on a call, they log in. They log when they start listening to the order, and then they log out. If an interception order is dealing with people who speak different languages, the interpreters that are in the interception room must also be certified, and they are documented in the interception order, or it's documented who is being used as interpreters. And what's interesting about interpreters on a federal level, they'll often bring in interpreters out of state to be used on these interception orders. All right, so this ends part 2 of our videos for Chapter 5. And again, you'll be required to submit an outline with the providing the information that's been provided to you in this second interview. And so take a look at assignments for the details of that outline. And so we have completed the Chapter 2 video. I'm sorry, Part 2 video.